This is day 2 of this panel sitting, but the first time we've been in the courtroom rather than on Zoom. Good to see people in real time, real presence. We have 2 arguments this morning, and other cases we'll consider without argument. First case of the day, United States versus Yvette Hills Robertson. Looks like Mr. Talbot gets to go first.
Good morning, Your Honors, and may it please the Court. This case presents a fundamental question about our advisory sentencing system. Must the district court treat the statutory index to the sentencing guideline manual as binding and mandatory when it produces an absurd result, like referring only to guideline sections that are inapplicable to the offense of conviction or the actual conduct of the defendant? The answer is no, because the guidelines are advisory. In rare cases like this, where the statutory index fails to refer to the very guideline section that clearly applies to both the actual offense of conviction and the underlying facts, courts must retain discretion to select that appropriate guideline. The district court's contrary approach below, treating the index as binding despite the obvious mismatch, constitutes reversible procedural error under Booker, Gall, and Kimbrough. The facts here illustrate the absurdity. Ms. Robertson assaulted a postal carrier because of a personal dispute, motivated by Robertson's belief that the postal carrier was having an affair with her husband. The confrontation occurred after the postal carrier had completed her mail route and had parked her vehicle. Ms. Robertson approached the postal carrier and scratched her and pushed her and screamed at her about the affair. The postal carrier was not seriously injured, and no mail delivery functions were obstructed or delayed. This was a personal dispute that in state court would be a misdemeanor simple assault. Below, Ms. Robertson was charged with and pled guilty to a violation of 18 U.S.C. 111A1, which is the federal assault on a federal employee or officer statute. And at sentencing, when the court referred to the statutory index of the sentencing guidelines, it only gave the sentencing court 2 options. It said that she could look and apply the aggravated assault guideline in 2A 2.2, which clearly doesn't apply under these facts because aggravated assault requires either a dangerous weapon, serious bodily injury, or strangulation. And it gave the court a second option, which was not the regular assault guideline, which is in 2A 2.3. Instead, the only other option the sentencing guidelines gave the sentencing court was the obstruction guideline in 2A 2.4. And so the sentencing court felt bound by the statutory index and felt that it had to select between either the aggravated assault guideline or the obstruction guideline, and was not allowed to consider the guideline that obviously applies here, which is the assault guideline, which is in 2A 2.3. And so the court picked the lesser of 2 evils, according to her, which is she picked the obstruction guideline because it was a little lower than the aggravated assault guideline. But the obstruction guideline does not fit either the offense of conviction, 111, nor does it fit the facts of the case. And that's because the obstruction guideline is meant to capture conduct that obstructs government functions. And on the undisputed facts here,
let me ask you that. The factual basis that was signed by defense counsel at the time indicated that the victim, the alleged paramour or whatever, was engaged in delivering mail at the time, was in her vehicle, that your client came up and stopped that process from occurring. Isn't that the factual basis for obstructing the mail carrier in official duties?
So I guess I disagree somewhat. So the factual basis asserts that the postal carrier was in the course of her official duties. That's correct. That's an element of 111. That's the federal jurisdictional.
Did your client assist in the carrying out of those official duties or interfere with the carrying out of official duties?
I think on the record we have here, I think probably neither. I think that her actions in this assault of the postal carrier neither obstructed nor assisted in the official duties. There's no evidence any mail was late, that the mail was not delivered that day, that the postal carrier wasn't able to finish whatever duties she may have still had for the day. She didn't miss any work. There's nothing in the record that supports that there's any actual obstruction of government functions, right, of what happened with the postal carrier.
Isn't delaying her ability to get, even if she had parked her vehicle, and it's not clear from the record where she parked the vehicle. Was she at the post office? Did she park her vehicle there? Where was the vehicle parked?
It appears that the vehicle was parked somewhere in a neighborhood. I don't think she had returned to the post office yet, because I think both Ms. Robertson was close by her own home, because I think what the PSR sets forth is that Ms. Robertson felt like her vehicle was almost hit by the postal carrier's vehicle, and that's when she got out and confronted her when the postal carrier parked her vehicle. So I think she's not returned to the post office.
Okay. So she's still in the course of delivering mail, even though she's not delivering mail at that moment.
I think the record is unclear whether there's any mail that still needs to be delivered. It says she had finished her mail route, which, I think a reasonable view of that is that she was done delivering mail for the day, but just hadn't returned to the post office. But in any event, there's nothing in the record that says that any mail failed to be delivered or was delayed, or that there was any effect at all on mail services by the virtue of this simple assault.
Do postal carriers do more than just deliver the mail? Do they sort mail at the post office? Do they prepare mail to be put in the truck for delivery? How do we know that she wasn't impaired from performing her duties by not allowing her to get back to the post office?
Well, first, I think you're correct. Of course, there's many other duties that perhaps this very postal carrier still had to do that day. There's just no evidence in the record that any of that was impeded. And that would have been the government's burden, right? It would have been the government's burden below to introduce something into the record via evidence at the sentencing or an objection to the PSR to establish that there was some sort of obstruction of any government function. And perhaps I wouldn't be standing here if they had done that. But based on the record here, the PSR says she had finished her mail route, and then there's no evidence submitted that there was any disruption of government functions. There's no restitution submitted on behalf of the post office or on behalf of the victim. And so there's just nothing in the record to support an obstruction of government functions.
Well, there's more to your issue, I know, than just what the evidence is as to what actually happened. But to return to the factual basis, which was signed by defense counsel, submitted in accordance with Rule 11F, they stipulate to the following: on this particular date, the victim, identified by initials, was delivering mail, and your client comes up and does the things that were alleged, including hitting her and some maybe yelling, "Get off the postal worker." So it does seem to me a pretty good argument there on the government's part that she was engaged in her official functions. Now, you say the PSR may have a different approach to it, a different set of tweaks on the evidence, but this factual basis, what do you do with that language that she was delivering mail?
Well, I guess I'm trying to point out the distinction between an employee being like in the course and functions of their duties, so a postal carrier. There's a difference between that fact, which is the jurisdictional nexus of 111, and whether the offense obstructed the performance of those duties. I think that's why that's the distinction the guideline's trying to make in 2A2.4, which is, not all assaults on someone who's at work, or, does that assault actually obstruct the actual performance of their duties? And I think this case kind of presents that factual scenario because there's no evidence of obstruction. Even though, of course, Your Honors have hypothesized of possible obstruction that could have occurred if she couldn't sort the mail or if there was other things, but there's just no evidence that occurred. And, Your Honor, even if, I guess, she still had mail to deliver, there's no evidence she didn't go deliver the mail. She was not seriously injured. This was, for all purposes, a minor scuffle where she was scratched and bruised. And so there's just no evidence that would have been the government's burden to establish the obstruction. The other point I want to make about the obstruction guideline is that guideline doesn't just apply if someone obstructs government conduct, which we're arguing that there's no evidence that happened, But the obstruction guideline, it also incorporates the official victim enhancement in Chapter 3, and the official victim enhancement requires not only that the person be a federal employee or officer, which is true here, but that the offense be motivated by that status, right? So when the district court below applies the obstruction guideline, Ms. Robertson is getting an enhancement like she targeted the postal carrier because she was a postal carrier. And there's also no evidence in the case for that, right? This was not a dispute over the mail being late. She didn't have a vendetta against the post office. This was a truly personal dispute against the postal carrier that would have occurred whether or not the victim was a postal carrier. And in the official victim guideline enhancement, it specifically says in the background that it doesn't apply to personal disputes. That's the language that the commission used. But when the court below is using the obstruction guideline, it is incorporating in that elevated base offense level those additional factors that aren't here. So there's no obstruction of duties and there's no targeting of the victim because of their status as an official. And so when the court below refuses to consider the assault guideline, which is in 2A2.3, which covers this conduct, and instead applies the obstruction guideline, it does so explicitly because it believes that the statutory index is binding. And that's the error we're talking about, right? The court was free to select the guideline that it thought was appropriate, but it wasn't bound by the statutory index. But below, the court says in the record at 88 that the appendix only gave her two choices, and that she had to choose between these two choices and could not consider what Ms. Robertson was advocating for, which is the regular assault guideline. And that's an error under the Supreme Court and under this court. It's an error under the Supreme Court because Booker made the guidelines advisory. And after Booker, the government repeatedly returned to the Supreme Court and advocated that certain parts of the guideline manual remained mandatory, and they were rejected each time. The most important one for this case is Kimbrough. Right? In Kimbrough, the government argued to the Supreme Court that the crack to powder cocaine disparity in the guidelines remained mandatory even after Booker. And the Supreme Court says no. In Kimbrough at 91, the Supreme Court says, we hold under Booker the cocaine guidelines, like all other guidelines, are advisory only. And so under Kimbrough, the statutory index is advisory. That's a part of the guidelines that is advisory. And when the court below held otherwise and said that her hands were tied to apply only one of these two guidelines that didn't fit, and was not allowed to consider the assault guideline that more closely fit both the offense of conviction and the facts of the case, that was an error under Kimbrough. Under Gall, the Supreme Court says that if you treat any portion of the guidelines as mandatory, that's procedural error. And so,
can you point us to any case where a court has not applied the guidelines set out in the statutory index? Any case that says application of the statutory index is discretionary?
So I'll point to this court's case in Grant. And so in Grant, this court says that, and Grant's in 2017, so it's a post-Booker case. The court says, quote, when sentencing a defendant, the district court must first determine which guideline section is most applicable to the offense of conviction, generally by reference to the guideline statutory index. And so in that quote, I'm saying that this court used the word generally with intention, because generally is this court's recognition that there may be situations in the future where the court doesn't have to rigidly follow the statutory index.
But I'm not sure you answered my question. Can you point us to any case where a court actually did not start with the statutory index or apply the statutory index?
Yeah, I don't have a case to point to you that specifically says that. I think there's probably good reason for that. I think that, at least in my 15 years as a federal public defender, the statutory index is largely correct, right? It largely does a very good job of pointing offenses to the correct guideline range. And so this sort of dispute, I think, is rare. And it has come up in the context of this assault guideline, which appears to be a drafting error, right? Where the 111 assault statute, which is the first statute in the chapter for assault under the federal code, that statute does not cite to the assault guideline range in the statutory index. And that is a drafting error, it must be, and the reason why I feel confident asserting that here in court is if you look at the statutes that do cite to the regular assault, they include assaulting the president, assaulting Congress members, assaulting members of the Supreme Court. And so if Ms. Robertson would have thought that her accuser was her congresswoman and committed this same assault, she would have got the lower assault guideline and it would have been 4 to 10 months. But the only reason she faced this almost 2-year guideline is because the statutory index neglected to reference assault in a case where the crime is assault, the facts are assault, but the assault guideline is not the one being referenced. And that seems to be a rare error that probably, I've never seen it, and so perhaps that's why it hadn't come up in this context for a court to decide.
But didn't the district court have the discretion, even though it felt bound to choose one of the two options, didn't it still have the discretion to depart below those guidelines for the very reasons that you urged the court to do so?
Yes, the court retained the discretion to impose a variance. But if you look at what the court said when it imposed the sentence, and this is in the record at 98 and 99, the court specifically tethered this sentence to both of the incorrect guidelines. It says, I'm imposing 21 months, and I'm going to note that that's in the middle of the obstruction guideline and at the bottom of the aggravated assault guideline. And so she tethered her sentence to the incorrect guidelines. She chose not to vary downward, but Ms. Robertson's entitled to a correct guideline calculation before the variance starts. And so it's not fair to start the variance from the incorrect inflated guideline.
All right, counsel. We'll hear from you again.
Good morning, Your Honors. May it please the court. The district court in this case correctly calculated the advisory guidelines in applying 2A2.4 to the defendant who pleaded guilty to assaulting a U.S. Postal Service carrier while in performance of her official duties in violation of 18 U.S.C. 111. Properly calculating the advisory guideline range is the caveat of Booker and his progeny. Booker rendered the guidelines advisory, but Kimbrough, Gall, and Pugh specifically provide that all of the guidelines are advisory. The sentencing court must still correctly calculate the advisory guidelines. And in correctly calculating the advisory guidelines, the court looks at the statutory index. In this case, USG 111, the statutory index lists 2A2.4 and 2A2.3. Interestingly enough, 2A2.3 is not there because in 1988, through Amendment 64, 2A2.3 was taken out of the statutory index for 18 U.S. 111, and as well for 18 U.S. 1503, which is interfering with the process server. So this was not some error by the Sentencing Commission. In 1998, they purposely took out 2A2.3 as applicable to 18 U.S.C. 111. In properly calculating the guideline range, the court starts with 1B1.1, which has the general application guidelines, and there are 8 steps that the court goes through. And the first one is to determine the offense conduct. And you look at the offense conduct, you look at the offense of conviction, which in this case was 18 U.S.C. 111. It was not assault. And then once the court goes to USB 1.12, it's referred to the statutory index, which lists the different the relative offense conduct guidelines. Then the court does adjustments, then the court determines the criminal history, and you get a range. And at that point, that's where Booker kicks in. The court can determine whether or not it wants to stay within that range. But to get to that range, the courts must still, as the Supreme Court dictates, follow those steps and correctly calculate the guideline range. A case right on point is out of the Third Circuit, Boney. In Boney, the Third Circuit went through basically the steps that I just described, where you start with 1B1.1, you go through the 8 steps, and you concentrate on the offense of conviction, which is the conduct charged and the count of the indictment. And here, the defendant, the count of indictment was in performance of her official duties. In Rooney, the sentencing court committed the error which this defendant was inviting the district court to commit, because there, the defendant was convicted of 18 U.S.C. 373, which is soliciting a murder for hire for retaliation. Under the statutory index, the applicable guidelines for that offense are conspiracy or solicitation to commit murder 2A 1.5 and 2X 1.1, which deals with offenses that are not listed. The court picked another one, 2J 1.2, which is obstruction of justice, which is not in the appendix. And the Third Circuit held that by selecting that guideline, the district court was violating the process required by the guidelines manual. That's not making the statutory index mandatory. This is basically following Gall and Kimbrough. You calculate your applicable guidelines range, and then you decide whether you veer from that range. But you still have to correctly calculate your applicable guidelines range. You can't pick, excuse me, you can't, if you have somebody with heroin, you can't decide that you want to use marijuana to calculate their guideline range. You have to still follow the guideline range, the sentencing guidelines, excuse me. Now, the defendant cites Grant and Principe for the proposition that the statutory index generally applies. But if you actually look at that quote from Principe, Principe is citing 1B.2a Note 1, which provides that the court should use the Chapter 2 guideline section referenced in the statutory index for the offense of conviction, and then gives 2 exceptions. One is there's a stipulation in the plea agreement that has a more serious offense, then you use the guideline for the more serious offense, and B, for something that's not listed in the statutory index. So the term generally in Principe was basically meant to encompass 2 exceptions, and those 2 exceptions do not apply here. There's no stipulation, and there's no statutory, there is a statutory provision for the offense of conviction. And now, specifically to 2A 2.4, the defendant focuses on the language obstruction. That 2A 2.4 is obstruction or impeding, and the note says the offense level incorporates the fact that the victim was a government official performing official duties. The defendant, under oath, pleaded guilty to assaulting the officer while she was engaged in her official duties. The factual basis, which again she admitted to under oath, she assaulted the postal carrier while she was delivering mail in her marked U.S. Postal Service car. That's what the defendant admitted to under oath. The defendant takes one little clause out of the PSI that indicated that she had stopped delivering her mail on this one street. She was on the street. She still had to go back to the post office. By being assaulted, that impeded her from either going back to the post office and delayed her going back to the post office, as in fact she had stopped delivering her mail, but the defendant pleaded guilty and admitted that she was delivering mail in her marked U.S. Postal Service. By asking us to take this one fact out of the PSI, the defendant is basically asking us to do what he claims the judge shouldn't have done, which was incorporate a fact that the defendant did not admit to. Also, contrary to what the defendant says, USG 2A 2.4 does not incorporate the guideline dealing with that the offense conviction has to be motivated by the official status of the victim. There's no indication that assaulting the U.S. Postal Service employee had to be motivated by her position as a mail carrier. That's not in the statute. That's not in the guideline. There's an enhancement for that if it was motivated by, if the official victim was, if the act was motivated by the role of the official victim. So basically, the government's position is that the court did not commit procedural error. It did what it was supposed to do. It followed the Supreme Court's guidance in Booker and its progeny. It correctly calculated the guidelines range. If it had wanted to deviate, it could have, and it didn't. It picked a sentence in the middle of the guidelines near the bottom. There was no error in this case.
All right, Ms. Walker. Thank you.
Thank you.
I want to start with where opposing counsel ended, which is that the court had discretion to vary from the higher guideline range, and that's kind of what we were talking about, Judge Ramirez, when my time ended. I want to say that you can't fix a structural error with a discretionary Band-Aid, right? And that the way a variance works is you start with a correctly calculated guideline range, and then the court considers 3553A factors to vary below or above that range. And the further away you get, the more reasons you have to give. And so in this case, the guideline range, we're arguing it doesn't fit the conduct in the case, right? And so to vary downward from the incorrect range would have started the variance without a strong foundation. And so I don't think that's how variances are supposed to work, right? I think the judge has to start with the correct range and then consider the mitigation. So if we apply that to this case, the range the court opposed was 18 to 24 months, right? And so Ms. Robertson would have to argue down from 18 months with her mitigation to get a lower sentence. And maybe the mitigation gets her to 10 months, right? But that's not what should have happened, right? If the guideline range was 4 to 10 months, her mitigating argument would have got her from 4 months to probation.
Let me ask a question about your premise. If the district judge followed the process that is set out through all our case law and started with the statutory index and chose from the two options available to the court, why is that an incorrect guideline?
It's incorrect because neither of the guidelines fit the offense of conviction, which is assault, right? And also they don't fit the facts of the case, which is a simple assault. And there is a clear guideline that applies to that conduct. It's 2A2.3. It has the same title as the offense that she pled guilty to. And so, we're not here asking the court to say, hey, let district judges just pick whatever guideline they want willy-nilly. This is a very...
We kind of are.
But we're asking for, in this very limited circumstance, which is this broken assault guideline, which is where the statute is for assault, the offense conduct is a simple assault, so it's not like Boney from the Third Circuit where the judge is trying to use some other conduct to move the guideline away. The statute is assault, the offense conduct is assault, and the guideline that we're asking to impose is the basic assault guideline. It is, there's like a trifecta of reasons why this guideline fits this conduct. And the court felt like it couldn't do that below and said that.
Can you address Ms. Walker's statement that this particular provision was taken out in 1998 from statutory index for convictions under 111A1?
Yeah, so that's when it got removed, and that's what I'm saying. I believe it must be some sort of error.
But not the district court's error.
Right. Exactly. Yeah, that's the Sentencing Commission's error. But the district court shouldn't have to impose an improper guideline because of an unelected political body's error, right? The district court is the supreme decision maker and has discretion to fashion the ultimate sentence. But this district court judge felt constrained by the commission's decision that I'm arguing is an error to not allow an assault conviction to go to the assault guideline. This court felt constrained. It's that constrainment, it's the court's refusal to acknowledge that guideline or to apply it, that is the error that we're saying requires reversal.
All right, counsel, you've made a forceful argument with us today.
Thank you.
We appreciate this. Both of you on this case, we'll take it under advisement. I'll call the next case of the morning,